Meryl Chertoff, and I am the director of the Sandra Day O'Connor Project. Thank you so much, Justice O'Connor, for setting the table for a successful conference. Ladies and gentlemen, it is my particular privilege today to introduce our featured speaker, the Solicitor General of the United States, the Honorable Elena Kagan. Solicitor General Kagan was confirmed as the 45th Solicitor General of the United States on March 19th, the first woman in U.S. history to hold that position. She joins a long tradition of legal skill, professionalism, and integrity, exemplified by some of her predecessors who are here with us today, Paul Clement, Ted Olson, and Walter Dellinger. Kagan served in the White House during the Clinton administration, first as Associate Counsel to the President, then as Deputy Assistant to the President for Domestic Policy, and Deputy Director of the Domestic Policy Council. In 1999, she returned to Harvard Law School to teach and was appointed dean in 2003. For those of you who, like me, are familiar with it, the law school of the 1980s, when she and I were students, and the one of the 1990s, was not so far removed from the fiction of the paper chase and 1L. It was not always the happiest place to be a student, and there was no dearth of complaints from members of the faculty either. But as dean, Elena Kagan implemented far-reaching reforms of curriculum and student life. She recruited new and talented professors from a variety of backgrounds. She won uniform praise from the faculty. And in fact, when she was nominated as Solicitor General and the press descended on the law school quadrangle, from Harkness Commons to Howard Hall, there was nothing but ringing praise for the dean. So when I saw her today, I was not sure whether to embrace the former dean of my law school or to salute her, since she is now a general. What an achievement. As a woman of her generation of women lawyers, the transitional generation between pioneers like Justice O'Connor and the young women of today who perceive few of the historical barriers that their predecessors did, it just makes me proud. I am proud that our young women have role models like Justice O'Connor and Elena Kagan, who we admire not just for who they are, but for their record of accomplishment. I'm delighted to introduce to you today the 45th Solicitor General of the United States, Elena Kagan.
Well, thank you, Meryl, for that wonderful introduction, and much more important, thank you for all the great and important work that you're doing on this project. Thank you, Justice Breyer, for being here. Justice O'Connor said that Justice Breyer has been fabulous, and those of us who know Justice Breyer know that he is always fabulous, so this is not a surprise. And Justice O'Connor, thank you for everything that you are doing and everything that you have done for this country for many, many, many years, for your entire professional career. I sometimes think, when I think of Justice O'Connor, I think, what an odd position she was in. There she was on the Supreme Court, where all the most important legal cases get. And on the most important of the most important cases, chances were that her colleagues were likely to be split 4-4, and that Justice O'Connor was going to be the deciding vote. Now, if you said this to the founders of the Constitution, we have this great system. Every really, really important legal case is going to get decided by one person. For many, many, many years, one person appointed by one president, confirmed by one Senate. Isn't that a great idea? I think they would say, well, no, it's probably not. But here's the thing. The way that Justice O'Connor performed that function, it was a pretty great idea. And that's because Justice O'Connor understood the special responsibility that attached to her role and performed that responsibility with a combination of modesty and grace and balance and common sense and understanding of the society in which she lived and the role of our courts in that society, and most of all performed that responsibility and that very special role with enormous wisdom. And so, Justice O'Connor, thank you for your service to this country. And Justice O'Connor continues to provide this service. This project on the independence of the judiciary is an extremely important one, which has done great work over these last 4 years. And of course, what makes it important is the importance of that value to our American system of law and our American system of government. And the project has really renewed awareness of this value, of its importance in our government, and has renewed awareness as well of threats to this value, and has shown the entire legal profession, and more importantly, the entire American people, and maybe most importantly, the next generation of Americans, why that value is important, and the sacrifices that we should make to foster and to protect it. So, Justice O'Connor, your work in this area since you retired from the bench has been no less important than the work that you have that you did on the bench. And again, the nation is in your debt. The value of judicial independence is, of course, a long-standing principle of American government. It goes back to the time of the colonists who protested judges who were subservient to king and to parliament. And it continued on as the founders of the Constitution were framing that document. Hamilton's words on this subject, he said, judicial independence is one of the most valuable of the modern improvements in the practice of government. And why was that? Because, he said, judicial independence was an excellent barrier to the encroachments and oppressions of the representative body, both Congress and the president. But throughout our history, of course, there have been threats to this value. This is understandable, given that the entire function and purpose of judicial independence is to check the representative bodies, both Congress and the president. It is understandable that Congress and the president sometimes view this as an impediment to what they want to do, and try to undermine this value and try to undermine the courts who serve it. And what Justice O'Connor's project has instructed the American people on is the importance of resisting those attempts to undermine the value of judicial independence, and that's why this conference is so important. Now, I've actually been thinking about independence from a somewhat different vantage point lately. The independence not of a judge, but instead of a government lawyer, and in particular of a solicitor general. And there is a long history, almost as long as the history of judicial independence itself, a long history of independence as it relates to the Solicitor General's office. And what I've been thinking about as I've performed this job for the last couple of months is what that long history and tradition is all about, what the independence of the Solicitor General's office means, and how it helps or how it can help to serve the independence and the integrity of the judicial system more generally. And indeed, this was the very purpose of the Solicitor General's office, was to establish this kind of independence. In the early years, litigation before the Supreme Court on behalf of the United States was conducted by private counsel. Government retained private counsel to argue in front of the Supreme Court on behalf of the U.S. government on matters of importance to it. But you can see why there was great concern as that system developed about this mixture of private and public interests and the danger of a conflict of interests that it posed. And for their part, the justices of the Supreme Court expressed a good deal of frustration over the lack of a consistent and centralized counsel for the United States. And so the Solicitor General's office was created to ensure a counsel's office that would represent the United States and no other party, that would answer to no one but the American people. And in 1977, the head of the Office of Legal Counsel, a very important office within the Justice Department, actually opined about the independence of the Solicitor General and how that independence was related more generally to the independence of the judicial system. Assistant Attorney General Harmon observed, "The nation values the Solicitor General's independence for the same reason that it values an independent judiciary. Such independence is necessary to prevent narrow or improper considerations, political or otherwise, from intruding upon the presentation of the government's case in the nation's highest court. The burden of history is that justice is done most often when the law is administered with an independent and impartial hand. Or let me read you another quote, this one from former Solicitor General Francis Biddle, who was commenting upon the nature of his office and said, "The office is responsible neither to the man who appointed him, nor to his immediate superior in the hierarchy of administration." I think that means the Attorney General and the President. Responsible to neither one of those. The total responsibility is his, and his guide is only the ethic of his law profession framed in the ambiance of his experience and judgment. Now, this is very congenial to a Solicitor General to hear. It appears that I'm answerable to nobody, only to the ethic of the law profession as sort of decided by me. So says, I want to make this clear, Solicitor General Biddle. Congenial, but is it really quite right? What would it rest on? And as I say, is it a bit more complicated than that? Now, one way to understand the Solicitor General's office is not that it's wholly independent, but that in fact it is dependent on a wide variety of actors, that it has ties and connections to multiple actors within our system of government. So that it's not that there are no masters, but that there are many, and that the job of the Solicitor General is to balance those masters and to accommodate them all, each in their proper places, wisely and well, and in so doing, to represent the people of the United States, which is the ultimate master. And I think that that's really what the Solicitor General's office is all about. Our relationships to and our responsibilities to the President and the Congress and the Supreme Court of the United States really define our role and the way we carry it out. So starting with the President, the Solicitor General is, of course, the principal advocate of the executive branch in the appellate courts, and the executive branch is headed by the President. The Solicitor General defends the regulations, the policies, the practices of the executive branch, again, a branch that is headed by a president elected by the people of the United States. And the President's position at the head of that branch, a branch of which I am a part, gives the President some authority, some rightful authority, to demand certain of my actions. There was, in fact, a good deal of criticism, most notably in the 1980s. There was much written about the influence of the President on the Solicitor General's office. And I think that in certain respects, this was unfair, because it is simply true that as the head of the executive branch, for which the Solicitor General is the principal advocate, the President will take a role, and a proper role, in certain of the Solicitor General's decisions. But the President, as I said before, is not the only master. Congress is just as important. The Solicitor General has the duty to defend all statutes except in very rare circumstances. Some statutes which impinge on the powers of the President, where the Solicitor General steps back and acts as the representative and advocate of the executive branch and of the President, and statutes that are clearly unconstitutional, patently unconstitutional. But except in those couple of rare circumstances, the Solicitor General is the advocate for our nation's statutory law, which means that the Solicitor General is the advocate for Congress, no less than for the President. And there are many good examples of the way in which this duty gets performed, many good examples over the years, even when the President does not like a particular piece of legislation, that the Solicitor General's office steps up and defends that legislation. Alex says that someplace in the audience, Ted Olson and Paul Clement are here. And some of the great arguments that they did in the Supreme Court were on behalf of the McCain-Feingold legislation, campaign finance legislation, which the presidents to whom they reported surely did not like, but Solicitor General Olson and Solicitor General Clement did their duty to the Solicitor General's office, which was to do their duty to Congress by defending that legislation. So the President and the Congress, but equally and no less importantly, the court. The Solicitor General's office is an officer of the court in a way perhaps that no other lawyer is, owing complete candor to the court in every representation that it makes. Now, what does this mean? Well, it means a variety of things, a variety of ways in which the Solicitor General's office acts towards the court in a way no private party would. First, the Solicitor General's office doesn't ask the courts to take all the cases in which it has an interest. And I know about this because every day a part of my job is to receive phone calls from irate agency counsel saying, why aren't you taking my case to the Supreme Court? And every day a part of my job is for me to say to them, you know, I have a responsibility to you, but I also have a responsibility to the court. I have a responsibility to the court to tell them what's really what are really the most important cases, so that they don't get overrun by cases of lesser importance that distract them from doing the truly important work that they ought to be doing. And so I'm going to have to tell you, the general counsel of some agency, no, I'm not going to ask the court to take your case, notwithstanding that you think that it's a matter of some moment. This is very different, of course, from what a private lawyer would do. I mean, call a private lawyer and say, I want to do a cert petition to the Supreme Court, and the private lawyer looks at the case and thinks, there is a 1% chance that this cert petition is going to be accepted. And what does the private lawyer do? The private lawyer says, sure. The Solicitor General's office doesn't do that. And in fact, the court relies on the fact that the Solicitor General's office will not do that. In a 1988 case, the court wrote just this. It said, quote, the court relies on the Solicitor General to exercise independent judgment and to decline to authorize petitions for review in this court. In the majority of the cases, the government has lost in the Court of Appeals. Otherwise, the court predicted, this court might well be deluged with petitions from every federal prosecutor, agency, or instrumentality, urging as the position of the United States a variety of inconsistent positions shaped by the immediate demands of the case rather than by longer-term interests in the development of the law. So the court relies on the Solicitor General really to think about those longer-term interests in the development of the law and to help it manage its docket. And the result is that we do get some benefits out of this in the Solicitor General's office and in the government more broadly, because the result is that when we do go to the court and ask the court to take a case, the court knows we're serious. And indeed, our batting average when we seek certiorari is very high, over 70%. A second obligation that the Solicitor General's office owes to the court is to be scrupulous in absolutely every representation that is made to the court. And here, too, I think the Solicitor General acts differently from the way a private attorney would. Of course, all attorneys are under an obligation to be honest to courts, to cite precedent that goes the opposite way, and so forth. But I think in a very special way, the members of the Solicitor General's office try to make sure that nothing in their briefs is overstated in any way or suggests anything other than the complete truth. And I was recently working on a brief of just this kind, where there really was some question about how strongly we should make a claim in the case. You know, should we state it as a kind of the sky is falling claim, or should we instead very upfrontly admit that the sky was not falling, that there was only a very limited problem facing the government? And the decisions of all the attorneys was to take that latter route, to say, you know, notwithstanding that we could present this as something where enormous interests were at stake, that wouldn't be quite fair to the actual facts. And even though we could get away with it, we won't. And we'll tell the court that our interests were limited in significant ways, and presume that they'll do the right thing with that information. And similarly, and in a way, again, that no private party would do, the Solicitor General's office sometimes goes to the court and confesses error, or acquiesces in a cert petition, notwithstanding that will mean judicial review of a government victory in the lower courts. Now, this is an extraordinary thing, really, for the government to go, for the Solicitor General's office to go to the Supreme Court and say, either we're not sure whether we're wrong, we might even be right, but we actually think you should review this case. We won, and we think maybe we're right, but we think you should review this case regardless because it's important for the long-term development of law. Or even more amazingly, to go to the court and say, we've looked at what happened below, and we actually think that the government was wrong in this case, and that you should reverse our own victory. And I recently had an opportunity to sign a brief of just that kind, a criminal defendant who was represented actually by a very poor lawyer who did not make the appropriate arguments on his behalf, who did not make the arguments that could have been made. And the Deputy Solicitor General in my office, a remarkable man who knows more about criminal law than probably anybody in this country, saw that there were arguments that really should have been made that suggested that a constitutional violation had been committed. And so rather than write a brief that just opposed the cert petition, which we easily could have done, and I doubt anybody would have picked up on this problem, we instead wrote a brief that said that there was a problem below, that the sentence had been imposed unconstitutionally, and that the court should vacate the judgment in the government's own favor. And this is fully consistent with the mission and with the practice and with the tradition and history of the Solicitor General's office over time. Solicitor General Sobolov put it like this. He said, the Solicitor General is not a neutral, true. He is an advocate, but he is an advocate whose client's business is not merely to prevail in the instant case. My client's interest is not to achieve victory. My client's interest is to establish justice. And similarly, Solicitor General Lehman once said, the United States wins its point whenever justice is done its citizens in court. And one more mark of the special relationship between the Solicitor General's office and the Supreme Court has to do with a peculiar practice known as CVSGs. CVSGs means call for the views of the Solicitor General. And these are cases, they happen about 20 or 25 times a year, in which the government has played no role, the Solicitor General's office has played no role. But the court thinks that the Solicitor General's office might have something useful, might have something valuable to say about the question whether it should take the case and spend its time deciding it. And I think that the reason why we get asked this question in these 20 or 25 cases, and I'm very familiar with these right now because a lot of these CVSGs gets done right in this month of May. The Solicitor General asks for our views over the course of the year, and we essentially agree to provide them by a particular point in May when the court can decide whether to take all of these cases. So every day these days, one of these is coming into me. And it's a quite remarkable thing because these are cases, as I say, in which the government does not have a direct interest, and yet the special relationship between the Solicitor General and the court has led the court to say we want to hear what the Solicitor General has to say about this case. It shows a special kind of confidence in the integrity and the independence of the Solicitor General, and we surely try to vindicate that. So all of these practices show this very tight, very special relationship between the Solicitor General and the court. In some instances, some people have led this practice, have suggested that the Solicitor General, because of these practices, should be called the 10th Justice. Now, actually, I don't think that the 9 justices would agree with that. Sometimes I think that the 9 justices think that the Solicitor General's office is the 35th clerk. But the relationship is no doubt very special, and the relationship between the Solicitor General's office and the court very much affects the relationship that the Solicitor General has to the President and to the Congress. So relationships to all 3 of these bodies, to the President, to Congress, and the court, responsibilities to all three of these bodies, again, the President, the Congress, and the Court. But Biddle, Solicitor General Biddle, I think, to go back to his quote, was right that although there are these relationships and although there are these crucial and important responsibilities, the Solicitor General's office is subservient to none of those institutions. The Solicitor General's office is subservient to and the representative of only the people of the United States. Now, this independence takes a kind of concrete form in the composition of the office. So when I became confirmed as Solicitor General, the first question everybody asked me was, are you staffed up yet? You know, because as these people come into the executive branch, the usual thing is that the head of the office will come in and that the head of the office will have 10 or 15 or 20 positions to fill. And I kept on saying, there's nothing to staff up. My staff is my staff. And my staff was Greg Gar's staff, and my staff was Paul Clement's staff, and my staff was Ted Olson's staff, and going back to Seth Waxman and Walter Dellinger, the staff of the Solicitor General continues on, notwithstanding changes in presidents. The only people who change in the Solicitor General's office are the Solicitor General herself and one of 4 deputies. And I think that this matters, that it promotes an institutional ethos of professionalism and nonpartisanship. And of all my goals, thinking about those words, professionalism and nonpartisanship, of all my goals, that is the most important one, to maintain that professionalism, to maintain that nonpartisanship, to maintain that strong tradition and history of integrity in the office, and by so doing, to ensure that the Solicitor General's office continues to play a key role in ensuring that the rule of law remains strong in this country. That, of course, is also the key objective of Justice O'Connor and the project on the state of the judiciary to ensure that the rule of law remains strong in this country. I honor everyone involved in this project for that important work, and again, I thank you for inviting me to speak here today.